There are a number of different codes and rules which a journalist will find themselves obliged to as they pursue a career in reporting. There are, of course, the legally binding jurisdictions that govern both the media and society in general. There are the MEAA Code of Ethics, which are designed to keep journalists honourable and unbiased. And finally, there are an ever-present range of ethical theories, which, when applied fittingly, can be used to justify a necessary breach to any of these ascending factors. Journalism is, to an extent, about knowing the rules and when to break them. However, in contemporary journalism, where the profession holds increased liability due to its now online landscape, it's more often than not about knowing the rules and when to stick to them. Thanks to a virtual public sphere, society are becoming far more inclined to form opinions based on the highly saturated bias that news stories present them with. So, what happens when journalists fail to meet their code of ethics in this new and complicated climate? They run the risk of provoking a trial by media, where society condemns a figure in the news based on the influence from publications, whether it be inadvertent or not. This is an ethical dilemma in the media and has unfortunately been embodied in many of Australia's high-profile cases. One of the best examples being the case of Baden-Clay. On April 20th, 2012, Jared Baden-Clay placed a call to police at 7:30 in the morning to report his wife, Alison, as missing. Her body was discovered in a creek in Western Brisbane on May 1st, and an arrest was made for her murder in June. The accused, her husband, Jared Baden-Clay. His trial began in June of 2014, and he was presented with a guilty verdict from the jury around a month later on July 15th. Baden-Clay launched for an appeal against his murder conviction on August 7th of 2015 and was successful in seeing his charges downgraded to manslaughter. The Director of Public Prosecutions, however, was quick to respond to this decision with a counteracting appeal, and the case was taken to the High Court of Australia. The proceedings, which started on July 26 of 2016, unanimously and conclusively found that his murder conviction should in fact be reinstated once and for all. So, ultimately, Jared Baden-Clay was a murderer who did have to be brought to justice at the hands of our legal system. Therefore, it's quite easy to understand the public's distaste for him. However, a pivotal quality of this same legal system is the presumption of innocence. This being that until Baden-Clay was officially sentenced with the murder charges, he did have the right to be viewed as innocent in the eyes of society. Thanks to highly emotive, invasive and widespread coverage from the Australian media, however, Baden-Clay was painted in a villainous light well before his sentencing. This onslaught of slander and defamation from reporters was highly consumed by the public, who, as a result of trial by media, viewed him as guilty long before his day in court. Journalists have an obligation to hold truth and balance above all else, above personal opinion, above meeting these consumerism demands, and above the general consensus of society. That is why the trial by media reporting of Baden-Clay was a classic violation to the MEAA Code of Ethics. The Media, Entertainment and Arts Alliance is defined as the most established union and industry advocate for Australia's creative professionals. This code, which dates back to 1910, breaks down into 12 clauses which were designed to commit media professionals, such as journalists, to values of honesty, fairness, independence, and respect for the rights of others. Code 1 is specifically relevant to the downfall of reporting that circulated during the Baden-Clay period. This code requires that media professionals will report and interpret honestly, striving for accuracy, fairness, and disclosure of all essential facts. Do not suppress relevant available facts or give distorting emphasis. Do your utmost to give a fair opportunity for reply. Now, let's use this ethical policy to examine one of the many defamatory examples of reporting that was produced during the Baden-Clay trial. In July of 2014, the Courier Mail were releasing daily updates to the Baden-Clay court proceedings, as a lot of publications were. At such an integral part in the legal process, the public was so highly attentive to the media, and the jury were as sensitive as ever to outside influences. This meant it was absolutely essential that a journalist's report carefully, factually, and above all else ethically in order to prevent a trial by media from occurring. Unfortunately, however, these obligations were not quite met. The Courier Mail Online provided a daily breakdown of the trial under recapped headings. Many of these included a selective snippet of unaccredited and circumstantial evidence from the trial that was, well, unfavourable to the defendant and therefore unethical to present to the public. For example, the title, Day 4, Accused Told Lover to Lie Low, was given to the article that covered the witness statement of Jared Baden-Clay's mistress. To report ethically and within jurisdiction, the Courier Mail should have attributed this source within their headline. For example, witness states that accused told lover to lay low. Without this kind of accreditation, the statement, which was not proven truth, reads as, the Courier Mail can confirm that Baden-Clay told mistress to lay low, which they can't. No one can. It was just the witness's words, hence why it's circumstantial evidence and simply unethical to present to readers as fact. This breaches the aforementioned code of ethics on numerous layers. It cannot be deemed as reporting accurately or honestly, as they have negligently authorized an alleged statement for the means of creating an attention-grabbing headline. Additionally, there was a failure to disclose all essential facts when insufficient accreditation was given to sources. Careless and unforgiving examples of reporting such as this were plentiful throughout the process of the Baden-Clay case, in print, online, and through broadcasts, which greatly moulded the way the public perceived him from the moment he was accused. This solidifies that the media in general had formulated a trial by media circumstance around the case, and therefore gave rise to an ethical dilemma by standards of the MEAA Code of Ethics. Now, we've seen the media sufficiently toe the line that the law had created around court reporting. We've also seen the media totally cross the line created by the first clause of their ethical code. However, there is one final moral convention, or line, if you will, that we must consider when framing a case around the unethical dilemma that was the Baden-Clay coverage. This being the deontological ethical theories. So rather, the moral philosophies of a reporter as opposed to their applied code of ethics. Ethical theories such as utilitarianism justify the means of an action when the greatest number of people benefit. Sure, the audience, being the greatest number of people, probably got the greatest satisfaction from the media slaughter, but unfortunately, no such ethical theory can be employed to justify the unethical calibre of reporting that occurred. At this time of highly saturated coverage, it's clear the media blurred the lines between reporting for the sake of educating the public and for the sake of entertaining the public. The former definition being the epitome of journalists acting as the fourth estate, and the latter, well, journalists selling themselves out ethically to keep up with consumerism demands. Aristotle's theory of tragic pleasure actually states that tragedy is a form of drama which excites pity and fear and explains why the public becomes so transfixed on tragic cases in the news. It's a theory relevant to all tragedies such as the Baden-Clay case, for example, the disappearance of Madeleine McCann or John Benet Ramsey. We, the public, become so engrossed in the gory details, like a car crash, we can't look away. And as consumers, we demand to know more. But that does not mean we need to, and therefore the media has an ethical decision to make. Is the story for public interest, or rather for public entertainment? Unfortunately, in this instance, they chose wrong. Now, This is not to say that the reporting of Bait and Clay should not have taken place. As our fourth estate, the media were well within their wheelhouse to bring the reprehensible actions of Bait and Clay to light in the public realm. However, constraints from their ethical codes and theories should have seen a much more impartial front from the media and, like it or not, a greater consideration for Bait and Clay to his presumed innocence. Moving forward, it is important that in such high-profile cases, journalists precedent their ethical values when reporting. This would see the production of more diplomatic, discerning, and relevant journalism that, above all else, steers clear of ethical dilemmas foreshadowed in the case of Bait and Clay versus the media. Thank you.